Hello, everybody. Welcome to this 9th edition and the first virtual edition of the University of Colorado Law School's annual U.S. Supreme Court Review. Although we're not physically together, this Supreme Court Review tradition continues robustly with over 1,000 registrants. We appreciate each one of you for joining us today. I know these are difficult times, but it's events like these that, even though through a computer screen, can nourish our intellectual beings and professional foundations, and perhaps even nourish our souls, not to mention get us a couple of CLE credits. This year, the annual parade of U.S. Supreme Court opinions extended into early July for the first time since 1996. And the court heard arguments via telephone for the first time in its history, including in a case argued by Colorado's own Attorney General and former Colorado Law Dean, Phil Weiser. Critical decisions were made on abortion, immigration, LGBTQ rights, healthcare, religious school funding, Native American rights, and executive power. I know we're all eager to hear our presenters' observations on this fascinating term. During the review, you can ask questions using the Q&A function at the bottom of your screen. You can vote on the questions that are of interest to you the most. Presenters will respond to questions following each presentation. I'm Jim Anaya, the Dean of the University of Colorado Law School. Today's panelists are the Solicitor General of Colorado, Eric Olson, CU Professor Scott Skinner-Thompson, and Aaron Van Oort, a partner at Faegre, Drinker, Biddle, and Reith. Their biographies, along with that of our moderator, Justice Melissa Hart, were emailed to you and are also available through the link that is posted in the chat. Briefly, let me just say how grateful I am for Justice Hart's continued involvement with this event. As many of you know, Justice Hart is a former member of our faculty and really a mainstay of this event. Likewise, all of our participants are repeat participants. All of our panelists are repeat participants. And so we so appreciate their willingness to share their perspectives on the Supreme Court term, on this Supreme Court term once again. So without anything further from me for now, I'm happy to turn the program over to our moderator, Justice Hart.
See, and I just made that mistake entirely on purpose to remind everyone that when you talk, you have to remember to unmute yourself and try to do it a little bit ahead of when you think you're going to be talking. Hello, everyone. It's nice to see that there are, at this point, 408 participants. I guess one of the advantages of moving to a remote world is that, in fact, we can be more inclusive, which always looking for silver linings, and that's definitely one. I am going to get out of the way, and Yesenia says 170 are also watching on YouTube. Wow. I'm going to get out of the way immediately and let our panelists begin, because there is a lot to talk about from this pretty fascinating term. I think I'm right that Eric Olson, the Solicitor General, is going to kick us off. Take it away, Eric.
Great, thanks very much, Melissa, and thanks to Dean and I and the CU Law community for putting this together. This is a really wonderful tradition, and I'm glad to be a part of it. I'm going to talk briefly today about some more practical advocacy lessons for all of us, but we really encourage interaction both among the panelists and with folks in the audience. So Melissa, if you want to talk to them about how folks can ask questions as we go, as opposed to wait to the very end like we sometimes do, that would make sure folks understand how they can participate.
Thank you, that's right. So I made that mistake by accident. So what we're going to do is, rather than having all three of the panelists talk and then have questions and answers at the end, we're going to have, after Eric is done talking, we'll have some Q&A around the types of things that he has talked about. As Jim mentioned, there is this Q&A function. For those of you who didn't know about this, I didn't until this week. At the bottom of your screen, next to the chat function, there's a Q&A function. You can type your questions there. I will be monitoring that. As Jim also mentioned, you can vote on which questions you want to have answered. And if I agree with you I will ask that question. So if it seems like you're being ignored, it's not that you're being ignored, it's just that I get the moderator's prerogative. So with that, I will let Eric take it away.
Great, thanks so much. And let me see if I can share my screen correctly here. Great. So I want to talk about 3 advocacy lessons from the court this year, and really driven from the perspective of an advocate. Colorado had 2 cases there this year that we argued, including the one that Dean and I mentioned. But I argued another case on the statutory interpretation case. We'll talk briefly. And as part of that preparation, I went and watched advocates for a week. This is one of the last in-person sittings. And I was really struck by a couple things. One was how often even experienced advocates make mistakes that all of us can learn from. And so the first one I want to talk about is this U.S. Forest Service, the cow pasture case, where Paul Clement argued it was his 100th argument before the Supreme Court, and which is only 2 other people have achieved that. And he is, by all accounts, one of the best arguments, the best advocates there ever. The question in the case was, did the Forest Service, the United States Forest Service, have the ability to issue a permit for a pipeline to go across the Appalachian Trail? And some environmental groups sued and said that by dint of statutory reassignment of authority, it was the Park Service, not the Forest Service, that could issue the permit, so the Forest Service permit was invalid. And the environmental groups framed the question presented to the court as whether the Forest Service has statutory authority to grant a gas pipeline right-of-way across the Appalachian Trail. Now, when all of us think of the Appalachian Trail or a gas pipeline across the Appalachian Trail, I think we think of something like this that comes to mind, where it's a very disturbing, disruptive procedure, and it just cuts a huge swath through the forest and is pretty clearly inconsistent with the nature of what we expect the Appalachian Trail to look like. And so at argument, Paul Clement gets his 2 minutes, which you now get 2 minutes free. He gets up, and the first question to him was from Justice Breyer. And he says, look, what I can't get out of the brief is what's the relationship between the trail and the pipeline? Like, is it this right across or is it down deep? And Paul Clement used no graphics in his brief. There was no illustration of what was happening, just a lot of text explaining pretty technical things about the pipeline. And I was struck by, as an advocate who spent much of my time in trial court, sort of how powerful a demonstrative would be. And I should say it wasn't just Justice Breyer who spent 5 minutes quizzing Paul Clement about where the pipeline was vis-a-vis the trail. Then Justice Alito took up the mantle. So Clement had 20 minutes and roughly half of it was spent, maybe a third of it was spent just explaining facts about the case. And then, so I just said, well, you know, what would be an easy way to avoid that? So I literally spent 15 minutes this morning and said, hey, why don't you just put a short graphic in your brief that says, look, the pipeline is 600 feet under the trail and it doesn't affect the trail at all. It comes in and out far away, you can't see it. It's a very different framing of the situation from what the environmental group framed it, saying it's going to go across the trail. And surely Paul Clement and his folks at Kirkland can do better than this mock-up I did in 15 minutes. But it reframes the question. It's under, not across, and it also shows sort of the craziness of the environmental group's argument that the Appalachian Trail, in essence, creates a curtain that prevents all pipeline development from Georgia to Maine, which is a pretty extreme position. And I think showing exactly what that would mean, where there's no consequence to the trail itself, would be a very powerful point of advocacy. And sure enough, the court figured it out on the end, and this is the way that Justice Thomas framed the question, in his opinion. They said, well, our question here is there permission to send a 600-foot pipeline, a pipeline 600 feet below the trail? And when you frame the question that way, the answer, particularly in this court, sort of flows naturally. So seeing this really sort of surprised me. Sort of Paul Clement seemed one of the best, sort of have trouble explaining some basic facts to the court. And so I asked on Twitter for folks for examples of good visual advocacy at the Supreme Court. And the best example that I came up with was Stephen Bright from the Southern Center for Human Rights in the Foster v. Chapman case a couple years ago. This is a Batson challenge, a race-based challenge to the jury composition in that case. He, in his briefs, used the actual documents and showed the actual documents the prosecutors used to show that there were discrimination, that all the African-American jurors on the left-hand side of the screen were highlighted in green and had a B notation. And then they had circled on the right-hand side of the screen all of the jurors who were identified Black as their race. And then on the bottom right of the screen, they had a B number 1, B number 2, listing sort of the worst Black jurors that they wanted to make sure that they got off of the jury. And he won 7-1 and reversed the capital conviction on Batson violations. But this was an excellent example of visual advocacy. And then I also came across sort of the worst example of visual advocacy in the court, which was in 1978, in the snail darter case. This is TVA, Tennessee Valley Authority v. Hill. The Attorney General of the United States, Griffin Bell, argued the case on behalf of the Carter administration. And the issue in that case was, can the endangered species status of the little fish, the snail darter, prevent the Tennessee Valley Authority from doing a whole bunch of dams? And the consensus, and he brought this in plastic. I think he tried to pass it around the courtroom to the Supreme Court justices to say, this little fish can't stop progress. And the court rejected his claim. So use visuals with care, but they can be very powerful. So that's lesson number 1. And then I want to turn quickly to just the lesson number 2 in terms of being an advocate, not just in front of the Supreme Court, but everywhere, is that the cases we get are much harder than they seem. And when you read an opinion or hear someone talk about what a case means, often it seems like the outcome of that case was preordained from the beginning. And I want to talk about the Lomax case, which is the case that the other case Colorado argued earlier this year. And it was one of the last ones argued in person in February before the court went to remote argument, to show that even cases that come out very stridently are really hard cases, and that you shouldn't give up because your case is hard. And in almost every case that you deal with as an advocate has some component that makes it very challenging. And it's really important to understand that component and stick to your guns as you push forward your view of the case. So the Lomax case was a pretty straightforward question. The informa pauperis statute, in the United States Code allows for prisoners to file civil lawsuits in federal court at reduced or deferred filing fees. The filing fee is currently $450 to go to federal court, and prisoners can file, if they qualify for informa pauperis status, by paying much less than that. They have to pay a percentage of their earnings, but in effect, it makes it much less. And the $450 often makes filing a civil case cost prohibitive to many prisoners. So in the Prison Litigation Reform Act, Congress added this statute that's on the screen that says you get 3 strikes. In other words, you get dismissed 3 times, and the dismissals that count, if you have 3 strikes, you can no longer file informa pauperis status. And the kinds of dismissals that count for strikes are dismissals that were dismissed on the grounds that they were frivolous, malicious, or failed to state a claim upon which relief may be granted. So this is a straightforward statutory interpretation case. And the question is a dismissal without prejudice, which for the non-lawyers attending means that the case is dismissed, but it doesn't prevent you from filing that same case again down the road, and you're not barred by doctrines of res judicata from litigating the merits of that case in a different forum or later in the same forum. Is a dismissal without prejudice a strike? That was the question. And it was really hard. There was a circuit split. Some circuits had come out, said it was, some circuits had come out, said it wasn't. And we took the position, we were defending the 10th Circuit that said it did count as a strike. And we argued based on the text of the statute. But we get to the Supreme Court And it was an incredibly hot bench. So we got out of the gate very hostile questions from Justice Kavanaugh, telling us our position was odd, from Justice Kagan, saying I hadn't answered Justice Kavanaugh's question, Justice Ginsburg talking about how unfair the result would be under our proposed rule, Justice Sotomayor telling me I had my facts wrong, and she was right, I did have my facts wrong on that one particular issue, but we were able to correct it. Justice Kagan again telling me that I was losing my argument, that there's a real reason that courts would pick one thing rather than another, and what people are suggesting to you is maybe there's not a reason. And then Chief Justice Roberts joins the fray. So 6 justices come in, and he says the textual argument isn't the end of the case. And it was an incredibly hot bench. I probably spent 150 hours getting ready for my 20 minutes of argument time. And during that 20 minutes, I was saying, I wish I spent more than 150 hours getting ready for this, because it was really, really difficult. So imagine our surprise when we get the opinion from the court this spring. Justice Kagan delivers it. It's unanimous, except for Justice Thomas didn't join one footnote. And it basically says, this is an easy call. Those of us who litigated this case know that it was not an easy call. It was a really hard case with good arguments on both sides. And so I use this as an advocacy lesson to say, like, the cases most of us work on, some of them can be really hard. And even when we look at other cases like ours, particularly when you look at court opinions, they often make the hard parts seem less important and make it look like an easy call, in part to get consensus on the court. But when you see something in the Supreme Court's opinion that says it's an easy case, it usually is far from it. And the last case I want to talk about is the faithless elector cases that Dean Anaya mentioned. There, as most of you probably know, the question is, can a state require the electors who are selected to vote the state's electoral college votes for president? Can the state make them follow the popular vote of that state? So in 2016 in Colorado, Hillary Clinton won the popular vote of the state. One elector said, in an effort to try to shake loose and make someone other than Donald Trump president, voted for John Kasich. We removed him from his job and appointed an elector who would vote for Hillary Clinton. He sued. The 10th Circuit said that we had no right to tell the elector how to vote. A similar case in Washington, the Washington Supreme Court said that the state can tell the elector how to vote. And the Supreme Court heard argument as to whether or not an elector can be bound by state law to vote for president in a certain way. In this case, we worked quite hard on it. Attorney General Weiser argued it. He did 7 moots to get ready for the argument, anticipated a lot of really hard questions. This was another really hard case. And what was striking to me about this case was, at argument, it was clear that people viewed this through a slightly different frame. Justice Alito, Justice Kavanaugh talked about the chaos theory that they were trying to avoid, and worked very hard to be pragmatic in their resolution. So we felt good coming out of argument, because some of the folks that we were most worried about seemed pretty focused on the practical consequences of an outcome where we lost. But then Justice Kagan again wrote this opinion, and I was struck by the 7, so unanimous for the states, 7 justices, including Justice Kagan, signed on to her opinion, and then Justice Thomas and Justice Gorsuch wrote a separate opinion. But I was struck in a case about what the original meaning of the Constitution was, that Justice Kagan was able to get Justice Alito, Justice Roberts, and Justice Kavanaugh to sign on to basically the shorthand for the living Constitution, and say that the Constitution doesn't in fact answer the question presented here. We have to look to the future, look to see what happened. And in reaching a critical conclusion, talked about in the second quote I have here, but our experience as a nation points us in the opposite direction to sort of rebuff a constitutional argument made by the other side. And I don't know whether it was everyone was trying to get their opinions done by the deadline, but I was struck by Justice Kagan as an advocate taking this case and pushing the envelope about what it means to interpret the Constitution and creating precedent that was joined by a broad coalition of folks who normally wouldn't join this, to say we look at what happened after the Constitution was written, and we look at the practice of our nation to help us understand what the Constitution means. And I thought that was surprising and a real testament to Justice Kagan as an advocate. And you can see Justice Thomas in his concurrence with Justice Gorsuch basically says, wait a minute, the Constitution's silent. That means it's up to the states. The states can control it. We don't need to put an affirmative meaning into the Constitution, as Justice Kagan did. But he and Justice Gorsuch were the only ones who really raised their hands and said, we're here for originalism, and we're going to keep interpreting the Constitution as we have in the past. I thought that was sort of a very surprising and a testament to Justice Kagan as an advocate. So that's the extent of my prepared talks. I welcome questions from the panelists or folks in the audience. Any reactions from other folks on the panel?
At the moment, there are no questions in the Q&A box. So I'm going to look to Aaron and Scott.
Yeah, I've got a question for Eric, and that is, it's your comment on Justice Kagan as an advocate on adopting certain methods of interpretation. We've seen a number of cases this year, over time some, but especially this year, it seems, where justices are signing on to opinions that reach judgments they agree with one reason or another, but where they can't possibly agree with the methodological approach. And Scott's going to talk about one of them, which is Bostock, the sexual orientation case, where Justice Gorsuch writes this complete literalist interpretation. And a number of justices, well, every other justice who signed on to that opinion does not agree with that approach. I'm wondering if you think that this is some new development where the justices consider themselves bound by results, but not approaches and rationale, or what's going on there?
Well, I think it's interesting. A few years ago, Aaron, in this talk, we were talking about, I think, the Arkansas case where they refused to recognize same-sex marriage certificates. And Chief Justice Roberts sort of signed on, slapping them down. And I think Jameson, my former partner, Jameson Jones, was in the audience. And we had a very lively discussion on this exact issue, which is, when you sign on to something, do you sign on to the outcome or the steps that got you there? And I think there's a difference in practice. I think Justice Roberts and Justice Kagan, ironically, are both folks that will sort of look the other way to get an outcome they agree with. And as you see here, Justice Thomas and Justice Gorsuch sort of are much more faithful to the journey as opposed to the destination. But I do think in the future, what we see in the presidential lecture cases will be used against to advocate certain positions about constitutional meaning. And I don't expect Justice Alito to do like he did this term, where he said, look, we don't look at original meaning. We don't look behind a state legislature, when he complained about what was happening in Louisiana for this. And now that we do this, we're going to do it a whole new way in some of the other cases. So I think it really varies, and it's not dispositive, but it's an interest. I mean, certainly Kagan and Roberts, to me, are the two that really are much more savvy about this, and how well it works is to be determined. I mean, what do you think in terms of folks?
No, I have the same thing. I think the chief, one of the hallmarks to me of what the chief has done is that the chief will sign on to results that you wouldn't ordinarily think he'd be aligned with, in order to get logic or rationale that he thinks is going to help in the long run. Whether that's the Affordable Care Act cases, whether that's the census cases. The census cases, they struck that down on an issue of administrative law, then introduced a whole new way for people to challenge regulations. And conservatives screamed about the result, but for the chief, I think, one of his long-term goals is to introduce more judicial oversight of regulations, and he got a majority to sign on to that there. And you just see him doing that again and again and again. And he did it again this term. The real question for me is, when is he going to start cashing in all of these, these little methodological things that he's planted there? And when is that going to come to pass? And we'll get into this a little bit later, but it looks to me in some other cases like he's taking baby steps. When we get to the religion cases I have, he's taking baby steps, chipping away and setting up an argument for reversing stare decisis on some broader things, but he thinks he needs to do it in about 6 half steps first. So to my mind, the chief is treats this more as a strategy game than any other justice I've seen. Scalia would just drive him crazy. As you point out, he refused to join footnotes that followed the wrong methodology. For him, it wasn't ever, playing a multi-step game. It was doing the case in front of you. And I think if he were around, it'd be driving him crazy right now.
I think there's something to be said for this, but I also and I agree that the chief is shrewd, and Linda Greenhouse has a great piece in the New York Times today about his shrewdness and particularly this term. But I also think that all justices have signed on to, in the context of constitutional interpretation, opinions that adopt living originalism, and all justices or living constitutionalism, and all justices have at times embraced outcomes that endorse originalism. And so I think that it's important to pay attention to when they sign on to opinions that embrace an interpretive methodology. But just as important, I do think, is the outcomes, because those outcomes and the results are just, we know that cases are decided based on facts, and distinguishing facts from of your current case from precedent. And I think the progressives, particularly this term, into the degree of cohesion that they showed in getting results that they wanted, notwithstanding that they don't constitute a majority on the court, are also demonstrating a long-term vision. I remember last year we had a discussion about the length of these opinions and the splintered opinions, and how many opinions were being written in each decision. I thought the liberals this year showed a lot of cohesion. There weren't that many fractured opinions. Conversely, I mean, you see Alito and Thomas continually writing, and I think that somewhat detracts and weakens their long-term position. Whereas, in several cases, the four progressives are able to just peel off one. Yes, maybe in Bostock, does Gorsuch's opinion embrace the broadest view of gender identity and sexual orientation discrimination? Of course not. But the decision and its outcome is going to speak volumes for decades to come.
Yeah.
So I'm going to interrupt here. First, there are a couple of comments that have come in on the Q&A. One is from Judd Choate, who runs elections in the state of Colorado, who says, "Great summary of Baca, Eric." The other is a comment from Lynn Siegel, who's watching on YouTube, noting, this is coming back to the Appalachian Trail case, noting that the undergrounding of the pipeline nonetheless has environmental implications, doesn't it? And wondering whether that was given enough account.
Yeah, so it certainly does, but I think, the advocacy, the environmental group framed it as it's coming across the Appalachian Trail, opening themselves up for the rebuttal. Actually, it's going way under, as opposed to going way under the trail still causes all these problems and concerns. And so I think, in the advocacy, the way it was, they were too ambitious in their framing on the advocacy group side, that allowed for the focus to come on the difference in what they claimed and what was really happening. Whereas I think a better approach would have been, here's why a 600-foot underground pipeline still causes real concern, and it's not that big of a deal. But that never got to happen, because at argument, the dispute was over where the pipeline was, whether or not there was any environmental harm from a 600-foot underground pipeline.
And then I'm just curious, and this is actually, I'm going to use this as an opportunity to transition. I think Scott is speaking next. Am I correct about that? And I'm curious, Scott, whether you subscribe to the view that I think I subscribe to, that another example of Chief Justice Roberts being willing to make moves that you might not otherwise expect in order to control things is Bostock, where he probably would have voted with the other justices, but he wanted to be able to assign the opinion so that it would be the opinion that Gorsuch wrote rather than an opinion that was a sweeping statement about the rights of gay and transgender people.
I think it's a critically important point, and I think related to what one of the questioners has referred to as his Johnny Appleseed approach is, and what Aaron's going to talk about is, while Bostock expanded coverage of Title VII to sexual minorities, there's still a lot to uncover, particularly when it comes to religious exemptions. And I think the chief was willing to give a little ground on coverage, enshrine a more textualist approach, and then will continue to stand up for religious employers when that clashes more squarely before the court. And with that, I'm going to share my screen. And just before diving deeper in, I want to also thank Justice Hart and Dean Anaya, and also Yesenia Delgado and Georgette Vigil from the law school for organizing this event and including me. So as has been gestured to in Bostock, the Supreme Court in a 6-3 opinion concluded that Title VII's prohibition on sex discrimination in employment precludes discrimination on the basis of gender identity and sexual orientation. And in many ways, as I was thinking about what General Olson was talking about in terms of advocacy lessons here, I think the advocacy lesson from Bostock is know your audience, right? And so here, the LGBT advocates who argued and litigated these cases for some time realized that in Justice Gorsuch, they had someone who was who fancies himself a textualist, and so they tried to make a very simple argument, which is that Title VII, precludes discrimination and consideration of sex at all as any motivating factor in an employment decision. And they emphasized in their arguments how, when you discriminated against someone on the basis of their sexual orientation, that decision invariably included sex in the analysis. Because, for example, if you were discriminating against a male who was attracted to other males, if you substituted that male employee with a female employee, they would not be discriminated against. And so the sex of the employee played a critical role. And the same holds true for someone who's transgender, who had been assigned a different sex at birth. And it was that relatively simplistic, mechanical argument that won the day and persuaded Justice Gorsuch to side with the LGBT advocates. Questions of legislative intent, questions of congressional history were all laid to the side. Justice Gorsuch said, we don't know. Probably true that the Congress in 1964 wasn't thinking about sexual minorities. It's true that Congress has introduced explicit protections for sexual minorities multiple times, but has routinely failed to enact them. But the court said reading tea leaves is secondary. We don't need to read tea leaves here. We're just going to go with the plain text. I think this opinion is critically important for the LGBTQ community, particularly the trans community. It's one of the first opinions from the court recognizing their humanity. And I think even the dissents show how far the court and society has come in terms of LGBTQ rights. Aaron earlier referenced Justice Scalia's, fidelity to his beliefs, and sometimes that fidelity would manifest in heated dissents towards the LGBT advocates and the quote unquote homosexual agenda. You didn't see that in this decision. Indeed, even though Justice Kavanaugh dissented, the tone of his dissent towards the LGBT community was much more gracious and conciliatory, which I think is important to note and is a testament to how far society and the court has advanced. That said, I think the religious exemptions debate about whether or not religious employers are able to get out of Title VII's prohibitions are going to be hotly contested. And I also think it's worth noting that while this is a watershed opinion, Title VII doesn't apply to employers with 15 or less employees. And so therefore, state anti-discrimination laws remain critically important.
Scott,
go ahead.
Someone typed into the question box that we can't always hear you as clearly. I don't know if there's a way to, oh, that's okay. Probably what it is.
I'll try to hold this. I'll try to sit more still. Is this better?
That is better.
Okay, great. One of the other critical decisions from this term dealing with individual rights was June Medical Services versus Rousseau. And I won't belabor this case because in many ways was very similar to the case decided about 5 years ago, Whole Woman's Health versus Hellerstedt. But I think it is emblematic of some of the trends we've been talking about with regard to the chief. The issue in the case was whether or not Louisiana's Act 620, which is a so-called trap law, a targeted regulation of abortion providers, was infringed on women's reproductive rights. And in particular, Act 620 required abortion providers to have admitting privileges at hospitals within 30 miles of wherever the abortion was being administered. The court, in essence, affirmed the district court's findings that this regulation from a health standpoint was unnecessary because abortions in most instances are incredibly safe, and therefore requiring an abortion provider to be able to get admitted, have privileges at a hospital was unnecessary to advance a health interest, and it imposed a substantial obstacle on women's right to choose because this regulation, if allowed to go into effect, would have caused many abortion providers in Louisiana to close. Importantly, the majority opinion written by Justice Breyer on behalf of, or excuse me, the plurality opinion written on behalf of him and the remaining liberals said that this was, in essence, an easy case. Again, another easy case that wasn't easy because the facts were so similar to a law that was struck down in Texas a few years ago. Justice Roberts dissented in that Texas case. He believed that that case was wrongly decided, but here he concurred in the judgment on the basis of stare decisis, believes that because of the factual similarity between the Louisiana law and the Texas law, stare decisis dictated that he strike down the Louisiana law. So I think that this opinion is another data point suggesting that Chief Roberts is quite the institutionalist and is committed to upholding the sort of stability and integrity of the court. What remains to be seen is what will happen when the multiple hundreds of abortion regulations that have been passed by states and localities in the wake of Casey over 20 years ago will fare as well. What will the chief do when we get laws that are slightly distinguishable from the Whole Woman's Health case? And I think that there's a high likelihood that the short-term victory for abortion rights advocates in Rousseau also portends losses in the future when there are factually distinguishable abortion regulations. The next case I want to talk about, a case that's critically important to the lives of hundreds of thousands of people living in the United States, is the Department of Homeland Security versus Regents of University of California, paired with another case called Trump versus NAACP. This case centered on whether or not President Trump's decision to rescind the deferred DACA, the Deferred Action for Childhood Arrivals program, complied with the Administrative Procedures Act. And here I pictured CU law professor Violetta Chapin, who's been a vocal advocate in favor of DACA, and her clinic has done important work on behalf of DACA recipients. It's a complicated case, but it basically comes down to the fact that the Trump administration, when it decided to rescind the protection of DACA, which allowed children who were brought here to the United States by their parents to have a 2-year forbearance on removal and gain employment, that decision to rescind those protections was arbitrary and capricious. And the reason was the court recognized that Trump had the power to rescind DACA, but the court, in essence, was underscoring that process matters, that jumping through the hoops matters, and that post hoc rationalizations or reasons are not cannot be accepted. That the reasons given at the time of the decision are the reasons that the court must evaluate, and that the reasons given at the time of this decision were thin. In my mind, this case builds on another one that we discussed last year, which was the court's decision overturning Wilbur Ross, the Secretary of Commerce's decision to put citizenship back on the census. There too, the court recognized that you may have the power at the end of the day to include this question of citizenship on the sentence. Just like here, they say the court may have the power to rescind DACA, but the court is holding the Trump administration's feet to the fire when it comes to process and saying post hoc rationalizations or pretextual reasons are not going to cut it, and the reasons need to be given at the outset so that those who challenge the administration's decision-making process know why the decision was made and can challenge it through the appropriate processes. Finally, I want to discuss another pair of important cases dealing with executive power, the cases of Trump versus Vance and Trump versus Mazar. These are two of the cases that deal with the extent to which President Trump is immune or not from different kinds of subpoena. In the Vance case, New York District Attorney Cyrus Vance Jr. Is conducting a criminal investigation into what he's investigating is somewhat vague, as the court notes, but investigating whether New York laws have been broken, purportedly related to the Trump's payoff of Stormy Daniels. And so he's subpoenaed Mazars, which is Trump's accounting firm. Trump went to federal court and said that to quash the subpoena, and said that he had a absolute right and he was absolutely immune from a state criminal subpoena. The Supreme Court, in a 7-2 decision authored by Chief Justice Roberts, and importantly joined by Trump's 2 appointees to the Supreme Court, Justices Gorsuch and Kavanaugh, concluded that that was not true, that he was not absolutely immune from such a subpoena, and noted that Trump's main argument was that, this criminal subpoena will distract him from his duties. But the court noted that it had rejected such a distraction-based argument multiple times in the past, most recently in the case of Clinton versus Jones, where Paula Jones was suing President Clinton for conduct that occurred before President Clinton was president, and Clinton tried to shut down the lawsuit, saying that if presidents are subject to civil lawsuits for their conduct before they became president, they would be inundated with suits and it would distract them. The court said, no, we've rejected that pure distraction argument before, and this is a state criminal proceeding where the interests of justice and society's interest in getting this information are, in essence, heightened compared to the interests at stake in the Clinton v. Jones case. So that's been sent back. And the court said Trump could raise other arguments, and we'll see what happens. But I, at least in this case, feel relatively confident that the New York District Attorney will be able to get the information they're looking for. The other case was distinct because the subpoenas came not from a local prosecutor, but instead from a series of House committees, also seeking financial documents, but for slightly different purposes, relating to see whether or not, in part, whether or not Trump was in cahoots with Russia. Here, same grouping of justices, 7-2 opinion, but the court said that the House subpoenas may be permissible, but they chided the lower courts for not giving due consideration to a separation of powers concern, and seemed to be more concerned about harassment of the president by Congress for purposes that were not closely related to Congress's legislative purposes. And they wanted the lower courts to consider what the legislative goal of the subpoena was, and whether or not the subpoena was, in essence, one of the more narrowly tailored means of achieving that goal. So I would say a bit more of a Trump victory as it pertains to Congress. I think a relatively definitive loss as it pertains to state criminal proceedings.
Before Eric and Aaron jump in, I want to just throw out some of the questions in the live feed, because I think it could be interesting to have all three of you comment on this. One, Jasmine asks, she essentially is channeling Alito's, if I use the word hysterical, is that inappropriate, dissent in Bostock, and asks, how broad do you feel the implications of Bostock might be, because it is a textualist argument? Does it have implications for lots of other areas, because the word sex now pulls in discrimination against transgender and gay and lesbian folks? And then an interesting question from Abe Cantor on YouTube. Do you have any thoughts about why stare decisis fights are so frequently played out in the abortion context? And then connected to that in a pretty remote way, another listener, Lori Capros, asks whether it's complex that Roberts relies on stare decisis in June Medical, but then actually doesn't follow stare decisis, but instead changes the test from Whole Women's Health by eliminating the requirement that the state show a benefit to women from the hurdles imposed. So, set of questions about June Medical and that question about Bostock that I'd like to throw out to Scott, but also to Eric and Aaron.
So great, all great questions. Thanks, Melissa, Jasmine, and others. As to the implications of Bostock for LGBT protections across the federal government, undoubtedly has broad implications, as Jasmine notes in her question. Sex, there are many federal prohibitions on sex discrimination, including in the healthcare context, including in Title IX by public schools. And this textualist argument, I think will be persuasive, and in many ways, it is indirectly contrary to how the Trump administration has been precluding protection for trans people in all those contexts. The question about stare decisis in the abortion context, I think, is super interesting and really insightful. My gut reaction to that is that this is a context where the court, since the 1970s, has been treading very, very cautiously. And stare decisis is an important principle, but it's also a convenient principle where the court does not want to make waves. They can rely on stare decisis to keep the law relatively stable. And I think because it's so contentious, the court has been trying to move in very limited fashion.
Yeah, I agree with Scott on the use of stare decisis and why it comes out there. It's a neutral principle that both sides can appeal to explain why they are or are not doing something. But yeah, I thought the same thing when I read Justice Roberts, the Chief's concurrence, which is that it seems strange to be concurring on the basis of stare decisis when you change the rationale of the past thing, and it raises the question, well, why else is he voting that way? And Scott, you referred to him as an institutionalist, and it seemed, at least me from an outsider, it seems in a lot of ways the chief will assign decisions to himself or write decisions in a way when he perceives that there are significant public perceptions at issue, and he wants the court to be perceived as not flip-flopping just because the members change. And this case may be exactly like that. They swapped a member, and to come out opposite ways on a case that could easily be portrayed as being the exact same question just a few years apart, probably got to him on that. But and this is what I was saying, playing a strategic long game. Well, if you're going to have that result, you might as well plant a controlling opinion because it's the narrowest grounds, and trim back logic you didn't like in the last one, and we'll see if that stands up. Bostock is interesting, and I'd be curious to hear what the rest of you think about this, because the logic that Justice Gorsuch used would be extremely broad logic, and the two things that he did is he took it down to the individual level, and he said the real question is what happens, would the treatment be different if the sex were switched? And so, of course, there are all sorts of places where you could apply that, being excluded from opposite sex bathrooms. Obviously, if your sex were switched, you wouldn't be excluded from that. And you do that. Sports teams, whether it's men's or women's, if I'm excluded from being on a women's sports team, obviously, if my sex were female, I wouldn't be done that, and that would be switched. I don't know that anybody thinks that's where the court's going to go with this, but it's one of the strange things about Gorsuch's logic, where he insisted that the only way he could get there is through this logic, sort of literalist approach. If you take it seriously, it goes in all sorts of other unanticipated directions, whereas something more pragmatic wouldn't. And it made me wonder, by the way, on the prediction that the chief switched so he could assign the opinion. I'm really curious if we'll find out after the fact if that happened, because I would have thought that if the chief had started in the majority and done the assignment power, he would have assigned it to himself. So he didn't have to put up with a Gorsuch opinion, because the chief would have been a whole lot more nuanced and pragmatic than Gorsuch was. I wondered whether it was Justice Ginsburg assigning it because he was the one most likely to splinter off, and therefore you assign it to the person who will splinter to keep them in the fold.
And my only observation is on Roberts as an institutionalist. I mean, June Medical was hailed in the press as a victory for sort of abortion rights advocates, but when you read it closely, it was a narrowing of the protections for women. And then Justice Roberts also really talked about the unadministrability of balancing tests as part of that narrowing. But then in the subpoena cases, sort of basically said, no, you need to go back and balance some more, particularly in the House subpoena case, in a way that bought him an institutional victory in that he was not seen as protecting Trump, but allowing a process to go on that would be far removed from the Supreme Court's fingerprints. And so I think there's a real political savviness to him and his concern about how the court is perceived, which I think is, it's unfortunate. I think it would be better if the justices were less Johnny Appleseed-like and institutionalist, and more, here's how I see the case and how we should do it. But it has been an interesting role that the court has been very assertive in controlling, in a one-step removed way, a lot of the questions on administrative review, et cetera, where they're not saying you can't do it, Trump, but you didn't do it right this time, and it's our prerogative to decide.
So we have a question in the feed about Trump versus Vance. Why weren't the other arguments against the subpoena subpoenas waived, since they weren't raised in the initial filings?
I don't know the answer to that, and I'm not sure that they weren't waived, or it was just that they weren't relied on by the district court. Yeah.
Yeah, I confess I don't know the answer to that either. It seems entirely possible to me that other arguments were raised in the initial filings at the district court. And it also seems entirely possible to me that a district court could say these arguments are waived once they are made. We actually don't know the outcome of that yet. Let me just see if there are any. So this is a question that's more general. There are a couple questions that are more general. I'm going to ask one now, and then I'm going to let Aaron talk, and then ask the second one. Do any of you have any thoughts about Justice Gorsuch's swing votes in McGirt and Bostock? Are they surprising? Do they say anything about how he might branch away from Scalia's textualism down the road?
Right.
That's really for everyone. So
yeah, I mean, as the former Scalia clerk, I'll take on the Scalia textualism. What Gorsuch does wasn't textualism. That was literalism, interpreting language that is logically different from what he said it meant, and that no one understood it to mean from a plain meaning, is not a textualist approach. It's a literalist approach. It sort of makes it into a fun game you play with it. But where he'll go with that, I mean, that leaves open the question, if it's not driven by a method, what is it driven by? And that's something that I don't know the answer to, and where it'll go on that. On McGirt, to me at least, that didn't come as a surprising vote on that, given some of the opinions that he'd written on the 10th Circuit in the background and what he did as soon as he started getting to the court. So that seemed to me much more in line with his background on that, and I wouldn't be surprised if we see more votes from him, in the Native American Indian law context, that are enforcing laws that have been there for a while, but nobody had just paid attention to or had ignored.
And I would say, just as a general matter, advocates of certain interpretive principles love to have outcomes that show that their principles outcomes, their principle overrides their policy preferences. So whatever you call Gorsuch, what Gorsuch did in Bostock, whether it's textualism or literalism or whatever, I'm sure that it is not disappointing to him that he has outcomes that sort of go presumptively the other way from his team, if you will, in sort of policy preference wise. And then on McGirt, I will say, those of you who've heard me talk about this before, I think it's a real, first of all, it's crazy that we view someone like Justice Gorsuch, who's, the parents were Washington insiders and moved to Colorado, as sort of providing a different view. But I do think, particularly on tribal and Native American issues, right, he's been out here, he understands what it really means on the ground, and having that perspective is really important to the court, so that as they address these tribal issues, they're not viewed as sort of law school theory, but in-person practice with real consequences. And so I think it's really helpful to have that perspective on the board. And like you, Aaron, I agree that it's not a surprise from what he did on the 10th Circuit, and he's very attuned to these issues, and I think a much more thoughtful way than many people expected, who didn't know much about him, expected him to be on this.
Great. So, Aaron, I think I'm going to turn it over to you to talk about your cases, and then we'll go back to questions in a few.
Awesome. So let's see here. If I have done this correctly, you guys should all now see the slide that says the religion cases. Can my fellow panelists just give me a thumbs up to confirm I've got it? Awesome. Okay. So here's the Supreme Court decided 3 religion cases this term, all of which had the result of favoring sort of the religious interests on this. Before I get into the details of that, I just want to do a setup on this and to say these cases are always contentious, and one of the really interesting reasons why is that they involve the relative power, the relative authority of different ways in which humans organize themselves and act in a collective way. And over history, and not just recent history, but over like hundreds and thousands of years, the relative prominence of these institutions has changed, and there have been a lot of fights over them. And so some of the major ways humans organize themselves are governments, political entities. Another way they organize themselves is businesses. Another way is churches, religious institutions. Another way is sort of informal associations on this. And what you see on some of these biggest cases and most difficult ones that have come up, on one more, I forgot, I should say schools. Schools is another major way people organize themselves. And so some of the biggest fights come up when one of the institutions, in one of the ways people are organizing themselves, is opposed to another institution, and they're figuring out who's going to prevail, who has the right to act, or who's subject to the other ones. And particularly right now, as the government takes a bigger role, becomes more developed, or businesses, corporations didn't used to exist. That's a relatively recent innovation in the history of humanity, and are now extraordinarily powerful and are exercising influences in a way they didn't, 300 years ago or before. A lot of these cases that we all like to talk about are sort of balancing the respective power here. And so just think about it as we get into this, how that interaction between those matter and what people are fighting about. So with that setup, let me go through here. The first case is the Espinoza case. And this dealt with providing funding by a state.
You're freezing a bit, Aaron. You're still frozen. Well, this is one of the challenges of doing these online and not in person. I don't know if there's an IT solution that we're going to come up with.
It looks like we lost him briefly.
Now you're mute.
Should be good. Can you hear me now, Melissa?
Yep.
Okay. I wonder if it choked my internet connection to try to do the slide too. So I'll go back and forth, do this. And so in Espinoza, what happened is Montana, the legislature passed a law that said that you could get a tax credit of up to $150 for contributing to organizations that gave scholarships. And the scholarships could be given to any private school, whether it was a secular private school or a religious private school. What happened is Montana had a constitutional amendment called the No Aid Amendment that said that no financial money could be given in any form to religious institutions. And the case went up to the Montana Supreme Court, and it held that the program violated that state constitutional provision and struck it down. And then it went up to the Supreme Court, and the Supreme Court reversed there. And because this makes it easier to see, I am going to try one more time here. If I can, to show the slides so that I can show you guys how the lineup happens.
Suggestion was made in the Q&A that you should tell your kids to stop streaming Netflix, but I assume you already did that.
I already did that. I instructed all of them to stay off the internet for an hour and a half, and it's darn near killing them. They are having to do things like go outside, and it's strange. So let me give this a try, and if it doesn't, then I know we have a backup with Yesenia. All right, but so can you guys see this now? And am I still streaming? Awesome. Okay. So here's the voting lineup, which is really, really interesting on this. And so that it's a 5-4 opinion on this, with the chief holding that if the basic ruling is that if you're going to create a generally applicable program for scholarships giving tax credits for private schools, you can't exclude the religious schools just because of that. This is another example of the chief writing narrowly, because he writes it to say that this is based on religious status and not on the use of the funds. We're going to test that in a moment on that. But the concurring opinions are all written in various ways to go further. And the dissenting opinions are all written to come back. And Justice Ginsburg here took a narrow view, saying, well, because the Montana Supreme Court struck the whole thing down, there isn't any discrimination left, and so there isn't any discrimination against religion. The court disagreed with that and said, no, the discrimination was introduced by the Montana Supreme Court, so we can address this. Justice Breyer reiterated his view that there shouldn't be rules here, so we should just look to policies. And Justice Sotomayor was kind of the counterpoint to Justice Thomas. Justice Sotomayor said it's just fine if we exclude religious institutions from some things because they're religious. And Justice Thomas, on the other hand, wrote the counterpoint to that, saying, no, we've interpreted the Establishment Clause all wrong, all the way. But let me get here to, I want to put this in context of the next case, and then set up a discussion about whether the court is being consistent or not on this. The next case is Our Lady of Guadalupe, which deals with the ministerial exception to discrimination laws. And Scott referred to this earlier. And the ministerial exception, the history of this is it says the free exercise clause of the Constitution prohibits the government from getting in the middle of religious institutions and deciding their doctrine, matters of faith. It said that's for them, and the government can't get involved in that. You know, as we think about how the government interacts with religious institutions, this is one way where they're just separated. From that first premise that they can't get into matters of doctrine, the courts have said also, because they can't do doctrine, they also can't get involved in governance of the churches. And from the issue of governance, another step along, they've said, well, if you can't do governance, you also can't then determine, get in the middle of employment decisions for certain people that are critical to the mission of the faith, which they referred to as ministers. The question in this case was, are teachers in private religious schools, and this was, I think, like a 4th grade teacher and a 1st grade teacher who taught a whole variety of subjects as you do in grade school, but among them the religion classes, did they fall within the limits of this exemption? And the court said yes. It was actually a 7-2 holding on this. It was not a narrow majority on this holding. But here's where the interesting point comes in on this. And that is, here's the logic. And the logic on this is saying, from the majority opinion, it's that the religious education and formation of students is the very reason for the existence of most private religious schools. And therefore, the selection and supervision of the teachers on whom the schools rely to do this work lies at the core of this mission. And this was the majority explaining why the government shouldn't get in the middle of the hiring and firing decisions, even if that meant that they would be exempt then from general anti-discrimination laws. But compare this now to the logic of Justice Roberts in the Espinoza case. And you should see this happening. The Guadalupe, the ministerial went off on the left, the one on the right. They're both talking about private religious schools, right? Guadalupe, in saying that the ministerial exception applies, says that the whole reason for the religious schools is for religious training. The tax credit situation that Justice Roberts described says this turns on religious status, not religious use of the funds, right? Where in schools where they said the whole purpose of the religious schools is for religious training. And then he says, you know, the department, the state in defending Montana said, well, look, the aid, you know, the tax credit could be used for religious ends. And the chief basically says, regardless, those considerations were not the Supreme Court's basis for doing it. They based it on status. And this is one, and you know, we'll open this. I'm really curious to hear my fellow panelists' discussion, but to me, this is another situation where the chief is resolving something on a narrow basis that doesn't really resolve the whole dispute, because this can go back now, and now you can fight about whether a limitation on state aid or tax credits that was based on religious use and not status would survive under the chief. But again and again and again, he's done this. He's did it in the census case. He's did it in other where you resolve just the case before you in some narrow way, and then you let it keep going on that in ways that sometimes seem to be highly technical. But it's one of the ways, again, of sort of minimizing the friction between the court and some other entity, whether it's the court and the president, the court and the churches, the court and something else. It's sort of taking down the breadth of what the court is doing. So then the last question here is the Little Sisters of the Poor case. This dealt with whether the Departments of Health and Human Services, Labor and Treasury, which collectively administer the Affordable Care Act, did they have the authority to create an exemption from the contraceptive coverage mandate that they created as part of their duties there? And the holding of the court was yes, they did have that power on this. This again was 7-2. And so the result was here, but the result was broad. But this is another one of those administrative cases where it doesn't resolve the whole question, because the majority held, yes, they had the power to create this. The concurring opinion by Justice Kagan said, yes, they have the power to do this, but it might have been arbitrary and capricious because the scope of the religious exemptions may have been gone farther than it needed to do it to fulfill the religious ones. And so she, as Justice Kagan did before in the voting rights cases last year, dealing with political gerrymandering, or she came out on the losing side of that, but wrote a concurring opinion basically giving a how-to manual for people to challenge those laws on other grounds. She did the similar thing here on that. But the bottom line holding on this right now is at the moment that the agencies had the authority to create the exception, but it's going to be remanded for further litigation on arbitrary and capriciousness. And under the Roberts Court's development, arbitrary and capricious review has more bite now than before. And so it'll be curious, you know, for me to see how this comes out. Let me just, I pulled this up, the text here that ended up being dispositive is that the agencies were giving the authority to create mandates and say what was required by the act. It says, as provided for in comprehensive guidelines supported by the agencies. And 7 members of the court said, well, this gives them sufficient authority to both say what must be provided in the insurance under the Affordable Care Act and to create exemptions from it. So let me stop sharing the screen here. And I'm quite curious to get my fellow panelists' reactions or to answer questions too about what's going on, and you know, is the court being consistent here, and how does this sink in? I think, you know, with what just Chief Justice Roberts is doing in other cases.
Reactions from Scott or Eric?
Well, I'll just say, I mean, it is particularly egregious in the religious context, but like Trinity Lutheran, which was the predecessor to Espinosa, according to the Supreme Court, was just a case about playground cover resurfacing and was not a case about the broader questions presented there of tax support for religious schools. I think Espinosa very clearly connects those dots, and you know, the notion that Espinosa is about is there some limitation there is not very persuasive. I think here there is a real desire of some members of the court to, and we saw it in Bostock and others, to really push on an expansive view of religion as a compromise to expanding other sort of civil rights, if you will, in our country, but they want to do so at the same time that they permit this. Now, I think there's been some interesting discussion about, I think David French wrote a piece about it a couple days ago, that it really is empowering individuals and some institutions and allowing the government to be much more comprehensive in its regulation of American lives, if you will. And it's a real power shift, but there is a real focus on, and you can, one of the questions, you know, noted the Catholic Church got, you know, $1.5 billion in government aid under PPP. It's not always a little or individual, but the religion cases tend to be sort of individual or small groups versus the government. And the small groups win, but we'll see how it plays out in the larger cultural context as we move forward, because they are moving targets, and the exception is going to grow and grow and grow. I think there's no way to take anything but that conclusion from these religion cases.
Yeah, I mean,
go ahead, Scott.
Oh, I mean, Aaron, I thought your presentation was fantastic, and that slide comparing Guadalupe with Espinosa, I think, is so illuminating. It brings to mind too, you know, so there's this use versus status distinction going on. It's funny that same distinction played a prominent role in you know, LGBTQ rights discrimination cases in the early days. By criminalizing same-sex conduct, are you focusing on use essentially, or conduct, or are you focusing on status or identity? And you know, the court ultimately concluded that conduct equals status. And it seems to be they're saying, well, at times saying the same thing with regard to religion, you know, that conduct is status. I don't know, you know, we've talked a lot about justices being instrumental and inconsistent. I'd have a hard time thinking of what I view as inconsistent interpretations happening in the same term on such a closely related issue. I mean, that's really powerful, and thanks for doing that.
One of the questions in the feed is essentially, is this the end of Blaine amendments, or so-called Blaine amendments, or where are we going to see litigation go on those, or are we sort of done?
I don't think we're done, because, you know, like I said, the chief sliced the onion very thin on this and dropped all sorts of bases for distinguishing everything in his opinion, you know, making it clear that the argument here and the logic below was based on status, not use, and that's all he was going to address, which leaves open for states and other entities to argue that they're restricting the way it's used, not status, and that'll be teed up directly. He also distinguished between tax credits and direct government funding, providing another way to do that. And then he distinguished between, you know, certain types of, you know, training, directly theological training, and other things. And so, you know, I think going back to some of the advocacy lessons that Eric did in general comments, none of these are easy cases anymore. They're incredibly powerful arguments and concerns, you know, policy concerns on different sides. And like I said, and as these institutions, these big institutions in our society figure out who's going to have authority in what areas, there are so many different bases that you could distinguish anything on. Mm-hmm. Which ones actually are going to carry the day will depend some on who the decision makers are, and some on how the advocates set it up and how they're able to frame it. So I think, for us to think that we've settled conflicts between church and state at this moment in history when they've happened for roughly the last 10,000 years would be a little arrogant of us. I think we're just in a different, the next set of issues will be defined by, our sets of laws and our sets of concerns, and we'll make progress one way or the other. But I don't think we're at any resting point.
I would just add, I mean, I agree with everything that Aaron said. I do think regarding the Blaine amendments that these decisions do make it clear that where a state is distinguishing between private schools and is sort of carving out religious schools, that is raising a real red flag for the court.
There's a question unrelated to any of these cases, which is, do you think the number of grants, certs granted each year is just going to continue declining and declining and declining? And if not, why do you think it seems to be so low right now? Of course, there's COVID, but.
I think this year was a special COVID related year because of all the scheduling. I mean, they had been on a gradual trend for a long time, but a fairly stable trend. And what did they drop? 20 below the ordinary trend this year? That's not going to hold, I don't think. I mean,
I agree, but it is interesting. I remember when Chief Justice Roberts joined the court, he advocated that the court needed to be taking more in more cases, and we've seen the opposite happen under his tenure.
And Steve Loddick makes a good point, that he's a law professor in Texas, that what the court, when you look at what the court is really doing, you also have to consider that they're vacating stays before judgment while the things are proceeding in the lower court should count as cert petitions as well. And when you look at that, they've had, the Trump administration has been unprecedented in how often they've run to the Supreme Court, to seek stays of district court judgments. They did it twice this week in two federal executions, entering opinions at 2 a.m. both times. And so I think that certainly shows that there's an appetite for jumping into political issues. Now, query whether that same appetite exists if it's President Biden instead of President Trump. But
abortion rights that are stopped in the midst of COVID.
Yeah, exactly. So I think we've seen the court be active. I think it's just a COVID issue. They really, going through the process of arguing a case and then having one with COVID, it was a real strain on the court to figure out how to adapt to this new normal. And they did a great job. Their staff, their clerks did great, but they were taking a step back to make sure they figured out how to do it. But I think the appetite remains for them to take more cases going forward.
So on that, Eric, recognizing that we cannot predict anything about what next week is going to look like, much less October, but do you think they're likely to do phone arguments again, or do you think that was a one and done and they'll either cancel or just do it in person regardless of the virus?
Well, they just issued the calendar for October in person. I think that they will do it. They can't wait. They're going to either do it by phone or in person, but they're not going to postpone again because they worked the kinks out. It was very savvy of them to have Lisa Blatt, who's one of the best, most experienced Supreme Court advocates, sort of go first. Everyone wondered why that was a case that was set for argument this term rather than pushed over, but she's really good. And they worked the kinks out. And I think particularly we argued at the end of the second week of telephonic arguments, and the difference and we had several testing calls with the court, but they felt very comfortable towards the end that it was working fine. And I think they're comfortable with this. They don't like it as much, in part because it invites more scrutiny. They, just like here, there's more than 200 people in the room that can participate, but they'll stick with that as opposed to postponing arguments.
Yeah, I agree.
The other questions in the feed are sort of, I think, hit on things that we've talked about before. So I guess with just a few minutes to go, maybe I'll invite a round of closing thoughts. And maybe I'll start, we'll go the reverse order. So I'll start with you, Aaron. Predictions for the next term, how about that?
Oh my gosh. Predictions for the next term. It'd be hard to follow up a barn burner like this one. Next term's got to be more boring, don't you think? You know, maybe some more patent cases, some more procedure, a little jurisdiction, throw that all in. No, I think, you know, looking ahead, partly changes in the court, I think, will depend on the election. I would expect that if Biden wins the election, then next year about this time, we will be talking about at least one retirement, and maybe have had one in the meantime, and maybe one more coming. You know, what I was thinking earlier is, you know, Scott had commented on how the, you know, sort of the 4 liberal members had really held together and been cohesive and had written fewer opinions. I think that's partly a function of time. The longer you've been on the court, the more you've had time to write your separate stuff. And now you're settling in, and, you know, the 2 newest members of the court are the Trump appointees. And so they're still having to address cases for the very first time, and which is leading to a higher number of separate opinions, for sure by Gorsuch, maybe a little bit by Kavanaugh. Over time, I think that'll settle down some. So I think, you know, what I noticed about this term, you know, this really seemed to be the year where it truly became the Roberts Court, where he's controlling the tone, he's controlling the voting. There are a lot of things in which, you know, his stamp was all over this. And how the court changes next year, I think, will depend on if there are changes in the membership, because that disrupts it. You know, when I was there in 2000, there had been no changes on the court for 9 years. And there weren't a lot of separate opinions, and they didn't have to talk to each other very much or confer very much, except on Bush versus Gore, because they'd had all the fights already. They knew where they stood, and only when you started getting new people in, then everybody kind of woke up and it's like, oh, there are things to discuss again. There are people to persuade. And so, you know, we're in that new persuading phase where we're trying to figure out who this court is. And this year, I think we started to see it. You know, Kavanaugh really is, like I thought he was going to be, kind of an old-fashioned judge. He reads the text, he reads the precedent, you kind of get to something that makes sense there. Gorsuch is very much, you know, a new libertarian on there, and a little bit unpredictable. We'll see where he ends up. But that's sort of my wrap-up thoughts.
Scott, how about you?
Yeah, I think it will continue to be characterized by sort of incrementalism and narrow holdings. But I also just want to underscore something I alluded to in my prepared remarks, which is what I feel is the court's, and again, here I'm borrowing from Professor Russell Robinson at UC Berkeley, LGBT exceptionalism. While the court has, in many ways, over the last 20 years, been consistently in favor of LGBT protections, I don't think the same can be said with regard to other marginalized groups, including abortion rights, including people of color, you know, as typified by the court in Shelby making the enactment of racially restrictive voting restrictions easier to enact. And so I think that, you know, for those of us who are care about anti-subordination, that we should pay attention to that and not let the court's LGBT decisions, as important as they are, distract us from these other issues.
And Eric, how about you?
Well, I'll be more depressing, picking up a thread that Scott started, which is, to me, the court has foreclosed the ability of people to ensure fairness in elections using federal court as a remedy, both in earlier decisions and they're just jumping in, including in Wisconsin, to sort of overrule a federal court saying it's too dangerous to have in-person voting, and making, you know, the irony was not lost on many that, you know, from their homes, they voted remotely to make people in Wisconsin go to the polls, you know, in person. And so I'm worried about the election because I think we're seeing a lot of uncertainty with COVID as it filters through into what our election looks like, that the court is going to play an unfortunately outsized role in resolving disputes that come up as to how states administer their election in the fall. And their past record with a huge glaring counterexample of the faceless elector case, where they did focus on pragmatic approaches to resolving this problem. But in general, they have been less inclined to intervene and support lower courts fixing problems that disenfranchise people largely based on where they live and what they look like. And so I'm worried about that. And I think that could have lasting consequences, but we'll see. And I also think that a lot of the incrementalism has allowed for state courts to play a bigger role in deciding some of these issues than we've seen in the past, because the court is less inclined to issue sweeping pronouncements and more inclined to fiddle and move and press. And I think we've seen an uptick in the role of state courts in resolving some of these issues that we traditionally look to federal courts to decide.
Well, I see that Dean Anaya has appeared, and I think that's because we're past 1:30. So Jim, I'll turn it to you to say goodbye. Thank you all very much.
Yeah, thanks everybody. I just want to mention or observe that a couple of the panelists made reference to Justice Gorsuch's opinion for the majority in Girt versus Oklahoma. And I want to highlight that was a truly exceptional decision where Justice Gorsuch found that much of Oklahoma is reservation land simply by reading and applying historical treaties. And indeed, that decision does speak volumes, I think, to Justice Gorsuch's judicial method as well as to his experience. Thanks to our panelists for terrific presentations and thought-provoking discussion, and thanks also to our moderator, Justice Melissa Hart. And thank you all for joining us. We appreciate the thoughtful participation. And finally, thanks to our staff working behind the scenes to make this event possible, including Georgette Vigil, John Sabre, and Yesenia Delgado. By the end of the week, you will all receive a link to the presentation and a survey to share your thoughts with us. And Colorado attorneys will receive a link for the CLE affidavit. We'll be in touch with you with future programming offerings. Have a great rest of your day. Goodbye.